All rise. We will await. Please be seated. Wait, versus what?
Thank you very much. And witness, welcome back. Mr. Steinberg, please proceed.
Thank you, Your Honours. Mr. Witness, I'm just going to go through two further areas. And to start with, perhaps I could just ask the court officer to call up the same page that we left on, and that was page 01090017 at 0041. And while the court officer is calling it up, Your Honours, may I ask that we go into private session briefly, as the paragraph deals with someone well known to the witness.
Private session.
We're in open session, Mr. President.
Microphone, please.
Thank you. Yes, we have 0041 up on the screen. The last three paragraphs of the page under the heading 3rd of January deal with the commencement of certain travels that you're alleged to have made during January 2008. At paragraph 135, you mentioned going to a place which is named there. Is there anything identifying about that, or can I mention that name?
Yes, it is. It can identify me.
All right. Well, did you in fact go to that place on the 3rd of January?
No, I didn't.
Does it follow then that you didn't bump into the two gentlemen that I mentioned there, in fact, three gentlemen that I mentioned there?
Let's do this. A private session. Let's begin with there and then ask questions. In private session, prosecutor, if you want, you can read out that passage so that it is on the record, and then if there are any questions, we can take those in open.
Thank you, Your Honor.
We're in open session, Mr. President.
Thank you, Mr. Witness. You just told the court in private session that the entire version you told the investigators about your supposed trip to Kip Karen salient between the 4th of January and it says you returned on the 14th of January for 10 days, was all made up by yourself and is untrue. You confirm that?
Yes.
What I'd like to know, please, Mr. Witness, is why was it necessary for you to make up this version about a fake trip that you never went on? Again, for the record, we have a long pause, Mr. Witnesses.
Okay, yes. I think we should go for a little bit of private session.
I'm in the chamber's hands, Your Honor.
Private session.
We're in open session, Mr. President.
Yes, thank you. So I was saying that we discussed on Friday that in your affidavit of 11th of August 2014, paragraph 8, you told, or you stated, or swore, that pursuant to the two investigators whom you name, pursuant to their request, and in consideration of the monetary inducement you'd been promised, you falsely claimed, amongst other things, that words such as Kimur, Kelda, and Kamama are used in Mr. Joshua Arap Sang's program on Cass FM's, quote, Le Ne Emet, which you spell L-E-E-N, new word N-E, new word E-M-E-T, and that these were code words meant to identify and victimize members of the Kikuyu community. Is that, according to your affidavit, what you claimed in your statement?
Yes.
And why did you, well, you say that this is false. Why did you decide to include those allegations in your statement?
This was to victimize Mr. Sang.
Did you know Mr. Sang personally at all?
No, I don't know him.
Have you ever had any altercations or run-ins or quarrels with Mr. Sang?
I've never seen him before.
Why did you feel it necessary to falsely implicate Mr. Sang in all of this?
Still, when we were discussing with the lady, she said that because Mr. Ruto was co-accused with Mr. Sang, so it could be good. My statement will carry more weight if I included the two in my testimony.
I see. And did you then, to the best of your recollection, make a statement such as you claim in your affidavit regarding the use of words like Kimur Kelda and Kamama? You understand?
Sorry?
So did you then, in your statement, tell the investigators that Mr. Sang used words such as Kimur Kelda and Kamama in his radio broadcasts?
Yes, I said.
Now, you can, if you like, have time to read through these paragraphs. It's the last two paragraphs on the current page, and the 4 paragraphs on the following page. But I think you can take my word for it that nowhere in this statement are those words mentioned as being uttered by Mr. Sang. Any comment on that?
Sorry a bit.
I'll repeat it. Nowhere in this statement you made to the investigators do you in fact say that Mr. Sang used the words Kimur Kelda and Kamama in his radio broadcasts. Why is that?
I've not seen.
You've not seen what?
I've not seen from the statement I gave to the investigators.
You mean,
If I wrote, if I said Mr. Sang used those words.
you mean you haven't had a chance to read today now as you're giving evidence, what you said in your statement?
I've not read it now.
Would you like to have a chance to read it?
Yes.
Have you read the 2 paragraphs that are in front of you now?
Yes, I've read them.
Mr. Court Officer, can you please call up the next page so that the witness can read the next 4 paragraphs? It's 0048.
Yes, the witness is reading at this moment. Paragraphs 181 onwards.
Thank you, Mr. Witness. You'll let us know when you're done, please. Are you done?
Just a minute. Okay, I'm done.
And do you see anywhere there any mention of Mr. Sang using the words Kimur Kelda or Kimama?
I have not seen.
So why is it, Mr. Witness, that in your affidavit you say that you make these false allegations that are not in fact contained in your statement?
As I had said earlier that when I was giving out my affidavit, I didn't have the statement at hand.
Yes.
Yes.
So is that your explanation, nothing else?
Yes.
I see. Were you in fact listening to CAS FM over the period of the violence? The election period and the period of the violence in Turbo and surrounds?
No, I was listening to Citizen.
And how were you in... I'm just trying to understand the thought process of how you were to incriminate Mr. Sang if you weren't even listening to his radio show. Can you explain that to me?
Yes, I could hear people saying. So I used what I heard people saying.
Was there anything to stop you from saying that you'd heard these things personally rather than giving the hearsay evidence?
Sorry?
If you were making this up, is there any reason why you didn't simply say you heard it yourself?
I'm not getting you.
All right. If I understand you correctly, one of your purposes in making the statement was to falsely incriminate Mr. Sang in the post-election violence, to fix Mr. Sang as well as Mr. Ruto. Is that right?
Yes, that's right.
And how did you intend to fix Mr. Sang? What did you want to tell the investigators that Mr. Sang did that would incriminate him falsely in the violence?
I wanted to tell them that Mr. Sang used his position as a radio presenter to air views which were against the Kikuyu community.
And does your statement do that?
Yes.
All right. I think I will leave it there.
Mr. President, it's been put to the witness, as I understood it, that if you were seeking to implicate Mr. Sang, why didn't you say you listened to programs? That's what I understood. And Your Honour, you got the terms of paragraph 180. So what was being put to the witness is contradicted by the witness's false narrative that he gave the prosecution when the statement was given, because there he does say that he listened to a program and he purports to give an account as to what Mr. Sang said. So, Your Honour, as I understood it, the objection of my friend, or the pretext, is completely wrong, in that it started from the proposition that if the witness was seeking to implicate Mr. Sang, he should have said he listened to the program. And Your Honour, my reading of 180 is exactly what he says. I remember in November 2005, so on and so forth.
Yes, my question was dealing with the election period, Your Honours, not what happened 2 years earlier. But perhaps let me just ask the witness this. Were you or were you not listening to KAS FM over the election period in 2007 and during the violence in January 2008?
Sorry?
Really, it's a simple question, Mr. Witness. Can you hear me?
Yes.
Were you or were you not listening to KAS FM during December 2007 over the elections and during January 2008 during the violence, the post-election violence?
I didn't listen to KAS FM.
Yes, that's what I thought. And in fact, at paragraph 47, we didn't turn there yet, but I will read it out. The last two sentences of paragraph 47, you're talking about the rally in Turbo early December 2007 as you claimed it at that stage.
Paragraph 47, you said?
47, Your Honours, and for the record, it's on at 0026. I'll read it out. You say, at that stage, this is early December 2007, I was not really listening to KAS FM anymore because I did not like the provocative statements and the incitements against the Kikuyu and the PNU supporters made by Sang. So, according to that, it confirms what you're saying today. You were not listening to KAS FM over the elections and the violence.
But not because it was against other communities. It was not my choice to listen to KAS FM. That is why I said I was listening to Radio Citizen because I liked it.
I see. So it's false to say that you stopped listening to KAS FM because you didn't like provocative statements that were being broadcast. Is that
Yes,
what
I was not even listening since the starting of it.
you never listened to KAS FM since the opening of the broadcast?
Yes.
I see. You mentioned earlier that you had heard other people saying what they had heard on KAS FM. What was that you had heard? Did you not understand the question, sir?
Yes.
I'm just finding the reference. My question was, I'm trying to understand the thought processes of how you were going to incriminate Mr. Sang if you weren't even listening to the radio show. Can you explain that to me? This is page 95 from line 10. Your answer was, yes, I could hear people saying, so I used what I heard people saying. What is it that you heard people saying, sir?
Yes, I heard from my fellow PNU supporters, those whom we could meet and talk, saying that Mr. Sang was telling people to vote unanimously for Raila Odinga and the ODM, so that if ODM won, we will be forming, the Kalenjin community will be part of the government.
And you said that you used what you heard people saying. Is that what you used to incriminate Mr. Sang?
Yes, that I used those words I heard people saying.
And how did that incriminate Mr. Sang in the post-election violence, sir?
That Mr. Sang, as the radio presenter, could use that opportunity to show the Kalenjin community that the Kikuyu community was evilish. For example, there is a paragraph I say that I heard people saying that Mr. Sang could bring the list of the ministers in the government, and then will say that the Kikuyu community is not fair. So that would incriminate Mr. Sang in a way that the people, the Kalenjin community, will be against the Kikuyu community, because many of the Kalenjins, I believe, used to listen to Kass FM.
And sorry, just probably last question. How, in your mind, did reading out lists of government ministers and their ethnicity, how would that lead to the violence? How was that connected to the post-election violence?
Yes, I was talking about that fairness, I wanted to incriminate Mr. Sang in that the Kikuyus were not fair in sharing out the government opportunity, the government jobs, ministerial opportunities.
Yes, I've heard you say that, but I wonder if you could answer the question. How is that linked to the post-election violence, sir?
Yes, that if the ODM was not going to form the next government, it will mean that people are going to the same regime, and that will make people say no to the government.
Is that all you have to say on that subject? Is there anything else?
I don't remember it now.
Thank you. Your Honours, I believe we've reached the stage where I've exhausted questions I can usefully put to this witness about his original statement, the truth of his original statement, and where false the reasons why he had provided false accounts to the investigators. At this point, if I may, I'd like to renew my application from Friday, and perhaps, as we did on Friday, this could be done in the absence of the witness.
Indeed. Witness, there are some legal arguments the lawyers will have to make at this stage. If you could step out of the room for now, the court officer there would put you somewhere else. But remain on hand. He will put you where you'll be on hand for us to call you back.
Okay, thank you, Mr. President.
Okay.
Mr. President, the witness has been escorted out of the transmission room.
Thank you very much, Court Officer. Mrs. Steinberg, you have made, I take it, the application you made earlier stands. You just merely wish to bring it back. Is that the case?
Indeed, Your Honor. So I will not repeat all of the submissions I made on Friday, but perhaps I can just make a few additional observations.
How many minutes will you need?
Probably 5 minutes, Your Honor.
Can we do that in 2 minutes?
I think I can.
Yes, proceed.
Your Honors, I think it is apparent the record will speak to itself that almost every material aspect of the witness's statement he is now resiled from, certainly every aspect which incriminates either of the accused in any significant way. Every single meeting which he testified about, or which he spoke about in his statement, at which Mr. Ruto was present or spoke, or supposed allies of Mr. Ruto spoke, has been denied. He's denied implicating Mr. Sang even when he didn't in fact implicate Mr. Sang. And in fact, it's all become rather ludicrous, and if it wasn't so serious, it might even be amusing. The witness, speaking of demeanor, I submit his demeanor has been very poor. He has frequently taken long pauses before answering questions, searching, I submit, for a credible answer. I've, on a few occasions, placed it on record, but really it doesn't reflect the true indication of his demeanor as those in the courtroom would have experienced it. Your Honors, I submit that he's been evasive on a number of occasions. For the record, I refer to the edited transcript, page 130, pages 80 to 81, where the same question had to be put to him 3 times, and that's just one example. Your Honors, he's failed to make concessions on a number of occasions where a reasonable witness, I submit, would have made those concessions. And strikingly, his evidence, particularly as regards to the reasons for his recanting and the source of the information of his recanting, has been evolving as his evidence has proceeded, in particular the role of the lady who I will not mention in public session. From originally being a person who simply introduced him to the investigators as per his affidavit, she now becomes the primary source and the primary reason for his giving the false statement. And the reference for that is again edited transcript number 130, page 79, in particular lines. Well, I have, unfortunately, timestamps on mine. Timestamp 1304, but it's the second half of that page. Your Honor, I think that in 2 minutes, that's approximately all I can cover. He maintains, Your Honor, obviously the version that he was induced by promises from OTP investigators to lie, to falsely incriminate the accused, which is in itself, I submit, is a clear indicia of hostility. And everything which has come out of his mouth over the last 2 days, in my submission, reinforces what I submitted on Friday.
Mr. Narasatsing, quickly, what's your position? Do you need to speak on this, and do you wish to agree, disagree with the prosecution, or elaborate in any aspect? Just quickly.
Mr. President, thank you very much for this opportunity. Two issues, Your Honor. First, on legal points, we don't have anything to add on the legal requirements that Prosecution Counsel had developed last time. We agree with those criteria. Secondly, Your Honor, on the facts, of course, we as Victims Counsel, we were prepared in a way to assess this witness testimony. And from the beginning of this, the testimony of this witness, we also acknowledge the fact that he has significantly derogated all the main points of the statement he had given to the prosecutors, investigators, Your Honor. Therefore, we think that we firmly believe that the Prosecution Counsel has gone as far as possible with the regular line of questioning. I think it's time for Your Honor to allow the Prosecution Counsel to examine this witness within the ways that Your Honor would allow, as far as goes closed and leading questions that might be allowed, Your Honor. Thank you.
Thank you. Defense, who speaks first? Mr. Khan.
Mr. President, I'm grateful. Of course, the witness has derogated. The witness said he told a pack of lies to the prosecution, and the prosecution swallowed it hook, line, and sinker. That's not the point.
2 minutes, Mr. Khan.
Your Honor, we go back to the earlier starting point. What is the prosecution trying to achieve? Originally, it was for leading questions, but they've put consistently a river, a deluge of leading questions since Your Honor advised them not to. And Your Honor, we didn't really object. So
We did not object, yes.
They've been given that opportunity. So Your Honor, what more? We say that the common law position remains a good starting point. That at common law, the reason for the opportunity to cross-examine was to neutralize damage that had been unexpectedly caused to a party who had called a witness believing the witness would say A when the witness said B. Your Honor, I've previously said that this is not such a case. The prosecution had notice. But Your Honor, be that as it may, we also have said that if the prosecution have objective evidence, for example, videos of rallies, newspapers, other evidence that they wish to put to the witness, I'm not going to object, irrespective of the labeling, whether it's called hostile, whether it's an indulgence to ask further leading questions. I'm not going to object, because our interest is that Your Honours be given an opportunity to get to the truth. In determining the truth, the question is not whether or not there's been departure from another story. It's whether or not the witness is attempting to tell the truth here in court. Now, Your Honours, I'm not going to make submissions on that, because any witness that has said he's told a pack of lies is in an awkward position. But, Your Honour, it's not as a simplistic position put forward by the prosecution, because repeatedly when he's taken to particular paragraphs, he is quite refined, we say, in distinguishing between aspects that are complete fiction, which he inserted into his account, and aspects that are true. And Your Honour will have, for example, paragraph 113 that was put to, paragraph 124 that was...
Mr. Khan, 1 more minute.
Gone into. So, Your Honour, the question is, have the prosecution established that the witness is not desirous of telling the truth? We say no. We say that the principle of common law has not been met. The witness may not have come up to proof, but that is not the test. That is not the acid test, the litmus test, for establishing whether or not they should be allowed to go further and discredit and impeach the credibility of their own witness, particularly one that has been told in emphatic terms, repeatedly, that if he lies here under oath, Article 70 will attach to prosecute. And, Your Honour, that's another indicia that Your Honours will no doubt bear in mind when assessing it. So, Your Honour, what are the prosecution trying to do? Why are they seeking to have this label of hostile? It's not clear to me, given that the primary application of my learned friend was to cross-examine. Well, he's been doing precisely that. Accordingly, the application really doesn't have merit, because he's been given the relief already that he requested.
Ms. Barsman, is that you?
And Mr. Just one issue. In relation to the lady, again, on many occasions there's been attempts, we say, that have not completely represented the evidence. But he didn't say he'd been introduced by the lady. he said recruited. And in relation to the contention that he hasn't implicated Joshua Sang, I didn't get that point because I referred in a previous objection to 180, paragraph 180. Sang was inciting the people by insinuating those that wanted to vote yes should not be allowed to remain amongst the Kalenjin. So that assertion, which I didn't get, that somehow he wasn't doing that which he said he did, namely trying to implicate Sang, is contradicted by the statement of the witness given to the prosecution, which he recants from. So I didn't understand that point at all. So, Your Honour, those are my submissions on this as to why the application really is moot now, given that the relief has been given.
Thank you, Mr. President. Well, we share these observations, in particularly the last. We do not really understand the purpose at this stage. I'm not sure how much is left of the examination in chief, but it seems we are nearing the end. The prosecution has been able to use the statement, to put it to the witness, to ask him his account, whether it's false or not false, and we've heard his answers. I know that this is not the position of the prosecution, and they do not like the answers. That, in our submission, does not make him an adverse witness. We are talking about demeanor and evasiveness. Whether or not that's obviously that's a subjective consideration, and we trust you, the judges, to give serious consideration to that. But when we speak about demeanor, we do have to look at the circumstances in which this particular witness finds himself. First, we are dealing with him through a video link. It is not always clear to us even what the questions are meant to be, let alone to the witness. We've heard our learned colleagues on the other side often say, it is a simple question. Well, maybe it is a simple question for the prosecution. It's not to us. We do not always understand, let alone the witness. He's uncomfortable. He comes here. He knows, and he's admitted before that he has lied to the prosecution. He's also being told, if he's not telling the truth, he might be facing sanctions. It's not a comfortable situation to be in. And in our observations, he has been giving answers, and he's been giving the answers that he believes are the truthful answers. The standard is not that there are two different accounts. We do know that there are two different accounts. But what is ultimately the principle is that the account that stands is the one he's given in court. I mentioned the other day, I already referred to the Limai case, and I also referred to the fact that there they had admitted prior statements, and I also declared some of them hostile. But the whole purpose, even in declaring them hostile, they looked at the circumstances of his testimony, they looked at his demeanor, but they also looked at the fact that his prior account was given by video, and so they could test the demeanor. And if you allow me to read out one passage, I have copies for you, and then I'll close it after.
1 minute.
Okay, but then shall I just read it out to you? And then later on, I'll make sure that you have the... So in paragraph 31 of a decision that's called Decision on the Prosecution's Motion to Admit Prior Statements as Substantive Evidence, and this is the Lima case, 25th April 2005. And in paragraph 31, the judges reiterate the principle of common law, and they say as follows. In accordance with long-settled common law principles, much more than some material difference between the oral evidence and a previous account was required before the conclusion could be reached by the chamber that apparently a witness apparently was not prepared to tell the truth in his oral testimony. Further, this is very important in relation to what we are submitting, the formality and thoroughness of the earlier interview by the OTP of each witness and the care taken to record the previous interview in a way which greatly facilitated its evaluation by the chamber were also material matters that influenced the decision that each of these witnesses was hostile. And I'm saying this, I am emphasizing this, because we do not know how this previous statement came about. We only have a statement, we do not have the questions. There could be very leading questions. We have no idea. All we know, and that's why he's here to explain it to us. That's the only way at this moment we can test his prior inconsistent statement. If the prosecution has more to provide to you, why you should rely on his earlier account rather than the one that he has given in court, we submit, the common rule is that what he's submitting here remains truthful, and because he's not shown not to be willing to tell the truth, he also should not be declared hostile.
Thank you.
If I may reply briefly, Your Honours, just on one or 2 points, less than a minute. I just observe that the issue and jurisprudence relating to the declaration of witnesses hostile dates way back to the days of Wigmore and Blackmore and early jurists of common law jurisprudence, and commentators going way back into hundreds of years, long before recorded testimony. So my point is that it is not dependent on the fact that a witness's prior statement must have been recorded. That is really not determinative. Just on the issue of paragraph 180 again, I emphasize that whole paragraph is referring to Mr. Seng's conduct in 2005, not with his conduct at the time of the post-election violence. And in my respectful submission, the council overlooked the fact that this is not just a simple failure to come up to proof. The witness has, in terms, recanted under oath and blamed the prosecution as being the source of his false evidence. And this is, in my respectful submission, about a stronger case of being a hostile witness as one is likely to encounter in a courtroom. Thank you.
We will render our ruling on the application of the prosecution on the 4th of September 2014. That the prosecution made an application for witness 604 to be declared a hostile or adverse witness on the 5th of September 2014, having heard the submissions of the parties, the chamber ruled that the application was premature at that time and directed the prosecution to continue to explore areas of critical interest from the statement of the witness. On the 8th of September, that is today, the prosecution has renewed their application for the witness to be declared hostile. And we've heard further submissions from the parties and the victims' counsel. As a preliminary matter, the chamber notes that the mode of questioning witnesses before the chamber is a discretionary matter, falling within the power of the chamber to fairly control the conduct of the proceedings. A hostile or adverse witness is not merely a witness whose testimony has become unfavorable to the case of the party who called that witness. The chamber notes that a classic common law definition of hostile or adverse witness, which has been adopted in some of the jurisprudence of the ad hoc tribunals, notably in the Limai case, is that a witness, a hostile witness, is a witness who, quote, who is not desirous of telling the truth to the court at the instance of the party calling him, unquote. This is a definition that has seen service in common law courtrooms as formulated in the Stevens Digest of Evidence. The Chamber considers that definition to provide useful guidance, but the definition does call for some elaboration. This is primarily because of this consideration. To declare a witness a hostile or adverse witness to the calling party on the basis of the formula that the witness is, quote, not desirous of telling the truth to the court at the instance of the calling party, unquote, may present uncomfortable concerns about premature findings of credibility made against a witness long before it is proper to make adverse findings of credibility. In the circumstances, the formula that a witness is not desirous of telling the truth is more meaningfully a matter of the complaint of the calling party. An application founded upon that complaint is an instrument of justice to the effect that without the remedy being sought, a criminal trial may never get at the truth. Upon receiving an application to declare one's own witness as hostile or adverse, on the basis of that complaint, the Chamber must then determine whether there is an objective basis for such a complaint. In this regard, the Chamber may consider a number of factors, including 1, whether the witness has been hostile in general demeanor. 2, whether there is any impression of evasiveness on the part of the witness. 3, whether the testimony of the witness before the court has been in whole or in part deliberately or systematically inconsistent with a prior statement. And 4, whether the witness has become systematically adverse against the calling party by not only deliberately impugning the credibility of the case of the calling party, but also by appearing systematically to support the case of the party opposed in interest to the calling party. Of course, there may be other factors, but these are enough for now. The Chamber emphasizes that any such ruling by the Chamber is without prejudice to the Chamber's ultimate determination regarding the truthfulness of the testimony of the witness. The purpose of making such a ruling is to facilitate the calling party in further elucidating evidence which may assist the Chamber's ultimate determination. In the present case, the Chamber has noted the extensive degree to which the witness's testimony has diverged from the statement he originally provided to the prosecution. In the circumstances, the Chamber considers it appropriate to permit the prosecution to proceed to explore these areas and the cause of such divergence by cross-examination. The request is therefore granted. Indeed, if I may add, the prosecution has, to some extent, done some of this, as counsel for for Mr. Ruto has observed. Nevertheless, we will permit the prosecution to explore further.
Thank you, Your Honours. Perhaps again, if I may ask, just for some clarification, I had intended to address certain topics beyond simply the discrepancies between his original statement and his prior version. In particular, I would like to explore how it is that the witness came to make his recanting affidavit, and in particular the affidavit which makes serious allegations against the prosecution, and as expanded also against a prosecution witness. And I submit that that is, will be relevant to a determination of this witness's credibility. So therefore I ask that in my questioning I be permitted some latitude to go beyond simply the four corners of the witness's prior statement.
Can I say, Mr. President, there's no objections from the defence, from my learned friend, to do that. No objections at all.
Mr. Kigen-Katwa?
We had indicated that we would have no objection to that either.
Very well. We will.
I have no objection, Your Honor. Thank you.
It looks like all parties are agreed, and this may be done. We will then bring back the witness. We know we're almost got quarter an hour or so to go, but within that time, something can be accomplished. Court officer, please bring back the witness.
Yes, Mr. President.
Witness, welcome back.
Thank you.
Mr. Steinberg would continue his questions to you. Thank you.
Thank you, Mr. Witness. I'd like to move away for the time being from your statement that you gave to the investigators in 2013 and return to the topic of the affidavit you deposed to in August this year. You know what I'm talking about? The 11th of August this year?
Yes.
Now, this affidavit is dated the 11th of August, and was it completed all on the same day, the 11th of August?
Yes.
Can you explain to the court, please, in your own words, how you came about to attest to this affidavit at the offices of Mr. Mutai on the 11th of August?
Sorry?
Explain to the court, please, how you came to make this affidavit before Mr. Mutai on the 11th of August. How did that come about?
Yes. Since I knew my testimony or my statement that I had given to the office of the prosecutor was false. So I took some time thinking what I should do, because at that time I was with the lady when we were discussing, but now it reached a point that it was me and me alone. So I thought of it, and then I remembered Mr. Mutai has been my friend for the last 5 years. So I went to him and spoke to him to assist me in drafting the affidavit and to send it to the office of the prosecutor that I have recanted my initial statement that I had given to the office of the prosecutor on the basis that part or most of the statement there was false and I had fabricated.
When did you come to this decision? How long before the 11th of August?
A few days before 11th of August.
And where were you when you made this decision? Were you in Nairobi already, or were you still at home?
I was still at home.
And we're not going to say on the record in public session where your home is, but it's a long way from Nairobi, is that right?
Yes.
Is it correct that you were due to travel to Nairobi to meet with the VWU that Sunday, that is the 10th of August, and depart for The Hague to testify the following day on the 11th of August?
Yes, it was true.
And is that why you were traveling to, is that why you traveled to Nairobi?
No.
Why did you travel to Nairobi?
Sorry?
Then why did you travel to Nairobi?